Good afternoon. Hopefully everybody can hear us. I'm Chris Michelik with McGuire Woods, and I'm here with my colleague Igor Babachenko. And we're here for a webinar on navigating the National Labor Relations Act for charter and private schools. As an initial matter, I have a scratchy throat, not COVID or anything, but just in case you're wondering if I lose my voice a little bit, I apologize in advance. Also, as we go forward, please send any questions you have to us as the event is going on. We generally like this type of thing when we can interact, and if you have a question, I'm sure others participating also have that question. So if you can text or send it, we will address it as it pops up during the presentation. If not, we'll have a time at the end to do this. Wanted to talk about what led to this presentation and our belief that there was some interest among clients for it. And that is, we've seen some recent, really within the past year, some beginnings of organizing activities by union entities that historically we haven't seen a lot of. One of those has been a union push that we've seen, and we've handled a number of these pro bono and have one in a larger sense that we're handling just regular now, to unionize small nonprofits. That historically has not been a focus of unions. We're also seeing activity beginning to pop up at educational institutions, particularly charter schools in some of the larger cities like Washington, D.C. And New York City. And so we found, and as we've had situations like that, we found that these clients understandably aren't familiar with the nation's traditional labor/union laws and how they may apply to them. So we thought this would be helpful for people. And so what we're looking for, this presentation is seeking to provide you, again, with a very basic understanding of the National Labor Relations Act in two areas where, if you're involved with educational systems, whether charter schools or private institutions, that you may run into these issues. One, from an organizing standpoint, and two, from what we're going to discuss, but from a discipline and performance standpoint. Now, I want to go through some scenarios which we have had clients, they're not a specific situation, but we've had clients deal with these, and it gives you an idea of what led to the interest in putting on this webinar. Scenario one, you administer a charter school founded to provide students a better learning environment. In the school's third year of operation, you continue to innovate and are making great strides in educating students. As you're going along, one teacher becomes unhappy and wants things more like they were when she taught in a public school. She tries to, quote-unquote, stir up trouble with other teachers, including, quote-unquote, bad-mouthing you in school policies. Things come to a head when she confronts you in your office on behalf of concerned teachers and becomes very agitated and belligerent. What do you do? This is a situation that, as administrators of charter schools and private institutions, you may encounter. In fact, we've had a number of clients encounter this in the past year or so. The second scenario we've also had, and we want to bring up and what led to this, scenario two, you are the headmaster at a prestigious, locally well-known K-12 private school. Many of your parents are highly educated, successful, and politically liberal. Your board of directors shares similar characteristics. Now, you learn of rumors that 3 of your best teachers are trying to get the other teachers to unionize and have invited them to an off-site meeting with a union representative. Again, you're confronted with that situation. What do you do? Our hope is that at the end of this presentation, you'll have a basic understanding of the issues at play and at least a basic outline of what to do. Now, to answer these questions and to determine what to do in those situations, we need to have you need to understand 3 basic things. One, you need to understand the National Labor Relations Act, and we'll go into what that act is and how it applies. Two, how it applies to your institution and the specific situation you're confronted with. Is it scenario one or is it scenario two? And the third thing is you have to understand the National Labor Relations Board and its processes. That's going to dictate your response some. And again, we're going to go through today and describe the National Labor Relations Act for you, as well as the National Labor Relations Board. Now, the National Labor Relations Act, that's the foundation of this entire area from a legal standpoint that we're talking about. And the Nlra is a federal statute that governs union matters for private employers. It does not apply to public employers. So if you'll see later, we'll talk about state schools. It does not apply to them. And in those situations, state and local laws are going to control unionization, what the rules are, those things. The National Labor Relations Act is governed. You heard me mention the National Labor Relations Board. That's the federal administrative agency that governs and monitors and administers, the National Labor Relations Act. Importantly, there's two things, particularly if you're an administrator or board member of one of these private educational institutions, to keep in mind. The National Labor Relations Act applies in both unionized and non-unionized work environments. So it applies even if you don't have unions already and you don't have employees talking about unions, you don't have employees trying to get a union in, the act, as we're going to describe, still applies. The second thing that I want you to remember with regard to the National Labor Relations Act is that its protections do not apply to supervisors and managerial employees. So everything we're going to talk about in a second regarding the protections of the Nlra, it does not apply to other school administrators. It wouldn't apply to assistant principals. If they're supervisors, you don't have to worry about any of this. They do not have the rights that we're going to discuss. Now, the Nlra is a fairly thick statute. It's got a whole bunch of different provisions that deal with many different aspects of union relations in the country. But for our purposes here today, by far the most important provision of that act is called Section 7. It's technically Section 207 or 157, of the National Labor Relations Act. We just call it Section 7. It forms the basis of what rights the act gives employees. And as you'll see on the screen, it states employees have the right to form, join, or assist labor organizations and to engage in, and this is the important language, other concerted activities for the purposes of collective bargaining, and shall have the right to refrain from any and all such activities. Taken from that and put in a colloquial term, this means that employees have the right to engage in protected, concerted activity concerning their terms and conditions of employment. If from determining what you can and can't do with regard to your employees under the statute, this is the most important concept for you to remember. And we're going to break it down so you understand how protected concerted activity, what that breaks down to on a piece-by-piece basis. So if you're faced with a situation, can you take an action and discipline an employee for doing something or tell them to stop doing it? You go to this analysis, and it's going to address the best way to move forward. One other thing that's important, and I'll get to the Section 7, there's also Section 8 of the National Labor Relations Act, and it's important in that it provides that you as an employer have the right, you have a free speech right, just as if an individual does versus a government entity. You have a free speech right. So if, as we get talk later on, you're facing organizing activity from your employees, or employee comes to you with a question about the union, you have, as an employer, the free speech right to provide your position. You can say, I don't like unions. I don't want unions here. You can provide, if this was a different type of presentation, we talk under the acronym FO. You can provide facts, opinions, and experiences, and they can be negative towards or against the union, just as they can be if you support a union. You can say that as well. The one thing as an employer that your managers, your supervisors, and you cannot say is your statements cannot contain threats of reprisal or force or promises of benefits. We put that, you may have heard the term tips. You can't threaten, interrogate, promise, or spy or surveil. Again, we won't get into great detail, but it's important that you understand that the Act empowers you as an employer with the right to free speech and to speak your mind. Now, going back to Section 7 rights, we talked about protected concerted activity. Does the activity fall within the protection, or is it something that's outside of that protection and you're entitled to discipline an employee, prohibit them from doing it, terminate an employee? Well, that analysis is very fact-specific, and we want to briefly go through a generic how you break down sort of a step-by-step of whether the conduct is protected or not. The first question is, does the activity concern the employee's terms and conditions of employment? If it does not, by terms and conditions of employment, we're talking about aspects generally related to their employment. It can be supervisors. They may not like a supervisor. They may like a supervisor who's been terminated. It may be their wages. It may be benefits. It can be vacation. It can be the coursework they're required to do. It can be school policies. All of that, there's a broad panoply of things that fall within terms and conditions of employment. What does not fall within that are things generally related to, and we've seen particularly in the past year to 2 years, things related to general politics. I don't like this politician, or I like this politician. It can be a personal grudge against a coworker. If they're making fun of a coworker, things like that, that falls outside of being involved with their employment. Also, if it's things, this pops up from time to time, inappropriate statements about a celebrity is another one that pops up. If it's outside of employment, you can stop them from making those statements, and you can discipline or terminate employees for making the statements, at least as far as the National Labor Relations Act concerned. The next step in the analysis, you want to look at, is the activity concerted? So is what the employee is doing, is it on behalf of 2 or more employees, or is it done by 2 or more employees? So if you have an employee that comes to you that is upset with just something about his or her actual work environment, she doesn't like the way you talk to her, something like that, and it's just for that one individual, that likely is not going to be enough to be concerted. However, it can be just one employee who comes to you and says, I'm here on behalf of all teachers, or giving an indication that she's concerned about a policy, for example, that applies to everybody. That likely is going to fall under the concerted category. What's more likely is you have somebody who is either sending out emails to coworkers trying to get them to join his or her position, or is copying multiple employees, or doing something in a group setting and confronting an administrator or supervisor about something that applies generally to the work environment. The last issue in your analysis to consider, the third question, is, all right, the There's conduct. It's on behalf of two or more people. It's a group of people. It's involving terms and conditions of work. It's, let's say in this situation, the starting day of the school day, or the ending day, getting rid of PE, any of those things. That then brings you to the last question: is that activity protected? In general, in the way the National Labor Relations Act in this section has been interpreted, it's been interpreted extremely broadly. That goes to the same thing with is that activity protected? It doesn't protect all activity. So if an employee makes physical threats, extreme physical threats, engages or threatens illegal conduct, or does things like in the private sector disclosing trade secrets, confidential student information that by law you're not allowed to share in public, things like that would take it outside of the protection. But it's extremely important, particularly for the administrators that are on this, to remember that the Nlrb casts a very narrow net in catching what is not protected. To put it probably in a better way, it views almost any conduct that doesn't lead to somebody breaking a law or imminently being a threat to cause physical harm as being protected. I think this is a good point to talk. To give you an example of this is a situation under the previous administration, basically by two administrations ago. So under the Obama board, and you will hear when my colleague speaks, the National Labor Relations Board is inherently a political organization. It's built to be that way. Under President Obama's Nlrb, the Nlrb greatly expanded, or at least maintained what had historically been a wide berth of what was protected. And there was a federal court of appeals, the Court of Appeals for the D.C. Circuit, was dealing with the situation, and in a unanimous decision by the panel, it dealt with, I believe it was in a strike situation, but one of the union members used pretty egregious racial terms. I believe the N-word was used, if I recall correctly. And the board said because it was in the context of labor relations, that was fine and it's still protected. It caused a stern rebuke from the D.C. Circuit, where the justice or judge that drafted the opinion said, we have ferreted out this nefarious conduct throughout our society, and we continue to do it today. And something to the effect of the Nlrb was the one location in the federal government that still sometimes tried to protect that conduct. I use that as an example, not to comment directly on the issue at play, but more as to show how wide the National Labor Relations Board historically views Section 7 protected conduct. If that's protected, you can guess that pretty much most conduct is protected. There's other cases where screaming and yelling at a supervisor, as long as it's being brought on behalf of other employees, in terms and conditions of employment, using very vile terms, that's been found to be protected. Slamming a chair against a desk in a small office was found to be protected. I say this, that in general you ought to come from the standpoint that there's a real likelihood, if it meets the first two aspects of this analysis, that it's going to be protected, and at a minimum you may want to contact your outside counsel. An area that we've seen popping up, particularly with the two areas that sort of led to this with our nonprofit clients and with our educational institution clients, but also in other private sector area, is our employers trying to apply or even try to remember Section 7 when dealing with social media issues. It's important to remember that Section 7 can apply to social media posts even though they're made away from work. So with Facebook posts or Instagram posts, unless you see the time something's done, it's not necessarily done at work, but frequently it will address work situations. And it can be situations where an employee or a group of employees says really bad things about a school administrator or a school supervisor. And if it is shown that they are just talking, and again, there are cases out there where, not in the school situation, but a private employer, a group of employees on Facebook out into the open, we're angry at a supervisor, and I believe called her a pig or something to that term, another offensive term that in a normal situation most employers would immediately terminate the employment. That was found to be protected concerted activity. So when you're confronted with Facebook or social media situations, you must do the same analysis that we just went through. And it's also a good point to remember that if your school has a social media policy, I know a number of educational institutions do. We've looked at a number of those, and in general, they tend to be more restrictive than what's permitted under the Nlra. So if you have an opportunity, you may want to go back and look at your social media policy. That generally gets into the other aspect of this, is that it's a good reminder once we go through everything that you go through and examine your handbook and policies for general compliance with Section 7. Under the Trump board, there was a little less emphasis on whether policies as written could be read in such a way that it involved or curtailed Section 7 conduct. We think under the new Biden board, when I say new, it's just now getting seated in full, you're going to see a return to that. So it's a good time to go through and say, read your policies. If you read the policy, could you see that as being read in a reasonable way that an employee could say, I'm not allowed to talk about my terms and conditions of work at work in a group setting. So it's good to go through that. One area I wanted to mention that's also come up with several institutions recently is with the unfortunate situation starting, I guess, last May with George Floyd. There were heated statements made by employees on social media on both sides of the issue, and frankly could be seen by other employees as being inappropriate, and it really put our clients in a difficult situation under the Section 7 analysis. In some sense, George Floyd and BLM is a societal, not a terms and conditions of employment situation. At the same time, frequently it involved comments about the workplace. So it really is a difficult situation to make the analysis here, but we wanted to bring this issue up. Question that frequently gets asked to Igor and me is, okay, we have an employee engaging in Section 7 conduct. Can we still discipline the employee? That's frequently where this pops up. Unfortunately, a number of times it comes up after the fact, after discipline's already been done. But the short answer is you can discipline the employee, but importantly, you cannot discipline them for engaging in that Section 7 conduct. And where that gets really difficult is if you're in your life is to make the best learning environment for your students, and you have, for example, a teacher that is purposefully being difficult and making it more difficult to provide that environment, is making your ability to administer more difficult. He or she wants to fight over every policy change. They're emailing other teachers. They even get combative. When I say combative, argumentative with you as the administrator. it can be really difficult not to discipline somebody in that situation. You at least have to be cognizant of the risk that it may be Section 7 conduct if you are going to discipline then. Importantly, however, engaging in Section 7 conduct does not shield you as an employee from complying with the employer's rules and expectations, so long as those policies, for example, don't themselves violate Section 7. So take another example. Say in our scenario 2, you have a teacher that is trying to get her coworkers to support a union. That's engaging in Section 7 conduct, but she also is late 3 times in a row for work. And under your discipline policy, anybody who's tardy receives a discipline. You can discipline that employee. Section 7 is only a shield with regard to the conduct that's protected by the statute, not other areas of conduct. The one thing of practical advice we tell our clients is that if somebody is openly engaging in Section 7 conduct like that, you want to be extra careful that you can make an objective showing that you would have disciplined that employee regardless of the Section 7 conduct. So one of the things we'll frequently ask you in that situation, well, have you disciplined other employees for similar misconduct? If, in the example I gave, you have another teacher that was tardy for 3 tardies at the same time and experienced no discipline, then that's going to be a problem. It's a little bit easier with egregious conduct. If you have somebody engaged in physical violence, sleeping on the job, or theft, you should feel more comfortable. But again, you want to be able to show you're treating that person like any other employee. So one area, and it may not be most of our education clients, or at least the ones that we've been involved with, they have differing views on this issue. One of the things that you can do to control your school environment is have a non-solicitation distribution policy. And that basically is there's certain things you can do to limit when and how employees engage with their fellow coworkers. So employees have the right to talk to their fellow workers about unionization, but if they're doing things like handing out pamphlets or handing out, you'll hear Igor talk shortly about authorization cards, you can limit when they can do that. And the important part there is you have to have a policy in place. It's basically that there's no distribution on work premises during working time. That means if it's in a working area, a classroom, something like that, while people are working, you can't distribute flyers. At the same time, with union authorization cards, that's more seen as solicitation. That can't be done when an employee is on what's called working time. That means not when they're on a break, not when they're in the restroom, but when they're supposed to be, in this case, actually teaching, whether the employee doing the soliciting or the other employee. Important thing to remember with that is you would have to enforce that rule uniformly. So if you're going to do that with regard to talk about a union, you would have to do the same thing for solicitations on Girl Scout cookies. The last area, main area with, again, sort of wrapped up in the Section 7 conduct, and we have seen this pop up some, is the law on union insignia. That is, somebody is unhappy and wants to wear a union button or a union pin. And we have employers that generally want their employees in they have certain dress standards. And the question is, what, if anything, can they do in that situation? And generally, employees may wear pro or anti-union insignia so long as it does not cause altercations or safety problems. It includes hats, buttons, and T-shirts. Obviously, if you're in a school environment and you have a dress that does not permit hats or T-shirts, you're more likely to see this pop up potentially with buttons or pins. And again, the company may enforce uniform appearance standards. In the school situation, a lot of it's going to come up with, in general, you're going to let your teachers have a decent bit of freedom. If they can wear things similar, supporting other causes, or American flag pins, that sort of thing, then they likely can wear a union pin in this situation. The last thing I'm going to talk about is not directly related to Section 7, but it's an issue that pops up particularly for our clients in states that tend to be less unionized, Southeast, certain places in the Mountain West, that sort of area. And those places have right-to-work laws. And we frequently hear that brought up in the Section 7 situation. This woman or man was out of line, and we're in a right-to-work state. Doesn't that mean I can terminate them regardless? And the simple answer is no. A right-to-work involves a completely different issue than whether you can terminate or not terminate somebody. Right-to-work laws are matters of state law, not federal law. And what they do is say that an employer and a union together cannot make employees join that union or pay union dues as a condition of employment. Other than that, they have no involvement whatsoever in the employment relationship. So where that comes in is in states that aren't right-to-work states, a union and an employer, if a union represents the employer's employees, can come to an agreement that employees must join the union or at least pay union dues, or they risk losing their job. And we wanted to clarify that just again. Igor and I have received this comment on a number of different occasions. And with that, I'm going to turn it over to my colleague, Igor, to talk about the National Labor Relations Board and its processes. Any questions that popped up?
None, so I will keep going. Thank you, Chris. Now that Chris has covered the statute, the National Labor Relations Act, I want to cover the National Labor Relations Board, or NLRB, and that is the federal agency that is tasked with administrating the National Labor Relations Act. Now, it's a somewhat unusual federal agency because when you think of federal agencies, you think about kind of rulemaking or kind of investigative powers. The NLRB does that, but it's also a adjudicative body. And so I'll discuss unfair labor practice charges with you as well, and those charges that are filed by employees against employers claiming that the employer violated the act. The NLRB investigates the charges. It also prosecutes the charges, and then the actual board will decide the unfair labor practice claim. Now, the NLRB, the actual board itself, it's a 5-member board, and it is inherently a political body. 3 members are appointed by the president's party, and 2 members are appointed by the party that's not in power in the White House. And the members serve terms, and the terms sometimes overlap with the presidential terms, but at usually fairly early in administration, the president's party will appoint the majority of the board. And you're about to see in August next month, you're going to see the NLRB shift from a 3-member Republican majority to a 3-member Democrat majority. And because the NLRB is an inherently political body, depending on which party is in power in the White House, can have a pretty significant effect on how the NLRB rules on specific cases. And you'll see things that were perfectly proper under a Republican administration all of a sudden shift and become a violation of the NRA under a Democrat administration, which makes compliance somewhat more difficult, but that's one of the interesting aspects of the National Labor Relations Board. Now, the NLRB is not just a 5-member board. The NLRB is the kind of the whole body, and the body is then divided into regions, and there is a general counsel that's kind of in charge over all of the regions. And again, the general counsel is appointed by the president. The general counsel serves a term, and you may have seen in the news a few months ago that when President Biden came into the White House, he asked the former general counsel, who was appointed by President Trump, to resign. And when he didn't resign, President Biden terminated that general counsel before the end of his term, which was a historically very, very unusual move by a president. It happened only once before. And the general counsel of the National Labor Relations Board sets the tone for the NLRB. The general counsel issues memos, which can range from, advice memos saying this is how I'm interpreting, this certain aspect of the law, and this is how we're going to proceed on this issue going forward. The memos are not binding on the 5-member board, but they give you a pretty good idea of, what issues the general counsel thinks are important, and what issues the general counsel is going to pursue actively, or at least tell the regions to pursue actively. Chris mentioned social media policies. During the Obama administration, the general counsel put out a memo on handbook policies in general, but a large part of that memo addressed social media policies. And the memo basically laid out, here are the different types of policies, for example, confidentiality or conflict of interest, or social media, and in the general counsel's opinion, these are the policies that are going to be lawful or unlawful under the NLRA. And then the general counsel instructed the regions and the regional directors to instruct their attorneys to pursue certain cases, to get those cases before the 5-member board and kind of to set that law. As far as the regions, there are 26 regional offices, and there's also sub-regional offices, but there's 26 regional offices. Each one has a regional director, and the regional director is the king or queen of that office. So, decisions on what cases to pursue and not pursue, decisions on, elections, they are made by the regional director. Regional offices are typically staffed with civil servants. They're not political appointees. A lot of them, have been within the regional office for a long time. They are Nlrb attorneys. There's also Nlrb field agents that go out and do certain things in the field. And even though the Nlrb is technically supposed to be a neutral body, the employees of the regional offices generally lean more favorably towards employees and against employers. That's just how it is. It's been that way since I've been practicing law, and I'm sure it's been that way since Chris has been practicing law and long before that. So what do the regional offices do? The regional offices oversee union petitions and elections. The regional offices also investigate, prosecute, and then it goes through a prosecution process where an administrative law judge decides the unfair labor practice claim. And I'll go into that in a little bit more detail. So the question comes up, well, how does a union become a collective bargaining representative? Meaning, how does a union come into a workplace and become the exclusive representative of the employees who are part of the union? Well, there's a process. So the first part of that process is that the union has to obtain authorization cards from at least 30% of the potential bargaining unit. And the potential bargaining unit is the group of employees that the union wants to represent. An authorization card, it's literally a card that says, I want this union to be my exclusive representative for the purposes of collective bargaining. So how does a union collect these cards? Well, oftentimes you'll see an employee, like a teacher, that wants his or her workplace to unionize. They'll go talk to a local union office, and the local union office is, okay, what kind of interest do you have? Can you gin up more? And that, the employee will start talking to their coworkers and say, hey, sign this card. A lot of times what we've seen is when employees sign a card, they don't fully understand exactly what it is they're signing. And the person leading the effort may tell them, oh, hey, sign this. This just tells them that you want more information, and that's all this does. Well, that's not the case. If you look at one of these cards, it actually says, I want this union to be my exclusive collective bargaining representative. Once a union obtains authorization cards from at least 30% of the employees it wants to represent, it can file a petition called a representation petition with the National Labor Relations Board. And the Labor Relations Board will see if they've got enough valid signatures, and that will start a representation case, which I'll go over with in more detail as well. Now, if a union obtains authorization cards from more than 50% of the bargaining unit or the employees it wants to represent, the union can ask the employer to voluntarily recognize it as those employees' exclusive collective bargaining representative. And, that'll happen. The union will approach the employer and say, hey, look, we've got signature cards from, 55%, 60% of your employees. This shows you that the employees want us to represent them. Will you voluntarily recognize? And depending on the situation, typically the answer is no, because as I mentioned, a lot of times these authorization cards are obtained under, not necessarily false pretenses, but without giving the full disclosure that should be given. If there is no voluntary recognition, then there is a representation case and an Nlrb overseen election. The National Labor Relations Board will notify the employer that a representation petition has been filed, and you go through an election process. The election process, it's fairly quick. Under the Obama administration, the National Labor Relations Board issued regulations that shortened the process. Before that time, it would be about 35 to 38 days between the time a petition is filed until the actual election. Under what we were calling the quickie election rules, it cut down certain deadlines, got rid of certain procedural devices. It cut down the average time from to about 23 days, a little bit more than 3 weeks. The Trump Nlrb walked back some of those rules. That got challenged in federal court. Some of that walking back got reversed. But where we ended up now is that the election process is not as long as it used to be, but it's also not as quick as it was under the what we call the quickie election rules. A union election process, it is what it sounds like. It's an election. The employees have the right to vote. They get to say yes or no. Yes, I want the union to represent me. No, I do not want the union to represent me. It's a private process. Your coworkers don't and shouldn't know how you voted. And if the union gets 50% plus one vote actually cast, not of those eligible to vote, then it becomes the collective bargaining representative for the entire unit. So if you've got 20 people in the unit, only 5 of them vote, and 3 of them vote for the union, well, the union represents all 20 of them. The big recent thing that's been happening with elections is the mail ballot election versus the manual ballot election. And traditionally, the Nlrb has favored the manual ballot, and you can think of that as an in-person vote. During a manual ballot election, there will be a board agent that comes to the workplace, they will set up a voting booth, which will be essentially a cardboard screen. There will be polling times or voting times that are set as part of the election, and employees will walk in, go behind this cardboard screen one by one, and cast their vote. Well, obviously, with the COVID-19 pandemic that started last year, it wasn't feasible or possible to have manual ballot elections. And so the Nlrb started ordering mail ballot elections. Now, mail ballot elections were allowed before COVID-19 pandemic, but the board ordered those really in rare circumstances. And I mean, really the manual ballot process, the board has called it in the past kind of the crown jewel of its procedure. But with COVID-19, that shifted. And ultimately, if there's a petition, the regional director decides whether there's a mail ballot election or a manual election. With a mail ballot election, ballots get sent to the employees' homes, and typically they get about 3 weeks to send their ballots back. So if the ballots go out on August 1st, the election document will say, to be counted, they've got to be received by the Nlrb by August 21st. So you get 3 weeks to vote. Now, we suspect, or we strongly suspect, that mail ballots are going to become much more prevalent even after the COVID-19 pandemic is fully under control. One of the Democrat-appointed board members recently commented that the Nlrb should look to modernize and streamline voting procedures. So we strongly suspect that there's going to be a push for more mail ballot elections, and you know, there's a possibility that you're going to have electronic elections. I mean, I don't know what else could be meant by the term modernizing. So that's just something to consider. Now, obviously, with a mail ballot election where you don't see employees go in one by one to vote, there's more kind of opportunities for foul play, so to speak. So if there's an election and the union wins, the union becomes the exclusive collective bargaining representative of the employees that it represents, and the employer's got to bargain with the union. That's the obligation. So that's the election process. Now, there's also unfair labor practice proceedings. And unfair labor practice proceedings start with a unfair labor practice charge. And that's when an employee goes to the Nlrb and says, I think the employer violated the National Labor Relations Act by disciplining me, terminating me, taking some kind of adverse action against me. Once a charge is filed, the Nlrb regional office will investigate. They'll send the employer a letter saying, there's been a charge filed against you. Here's the general allegation. You terminated employee X for engaging in concerted protected activity. It's going to ask you for a position statement, basically a letter that says, describe what happened and tell us why you didn't do anything unlawful. It's going to ask you for documents, give employee X's personnel file, provide documents that show that you disciplined or terminated other employees for similar reasons. And it potentially is going to ask for interviews with the supervisors involved, and the board is going to want to take affidavits from those supervisors. So once the regional office gathers the information, it makes a decision on whether to issue a complaint. And generally, if the region finds that there's an issue of fact, a he said, she said, so to speak, the region will issue the complaint, and it will begin what we call a quasi-judicial process. There's a complaint, the employer answers it, the Nlrb region may issue subpoenas for documents from the employer, and the employer will have to respond to those as appropriate. And eventually there's going to be an evidentiary hearing in front of an administrative law judge. And when I say evidentiary hearing, it's essentially a full-blown trial like you would have in a state or federal court. The employer puts on witnesses, puts on documents. The Nlrb puts on witnesses, puts on documents. The Nlrb cross-examines the employer's witnesses and vice versa. After that process is done, the ALJ, the administrative law judge, issues her findings of fact, and it's a recommendation. It's a decision, but it's a recommendation, and it'll be something to the effect of, based on these facts, the employer terminated this employee for engaging in protected activity, and I recommend ordering, back pay and potentially reinstatement of the employee to their former position. Now, when I say it's just a recommendation, it's just a recommendation because the losing party can file what's known as exceptions to the 5-member National Labor Relations Board. And an exception is essentially the ALJ got this wrong, reached wrong conclusion, and this is why, National Labor Relations Board, please reverse the ALJ. Now, if neither party files exceptions, the ALJ's recommendation does become the final decision. If exceptions are filed, both sides submit briefs or legal papers and arguments to the Nlrb, and then the Nlrb decides whether the ALJ got it right or got it wrong. If the Nlrb decides the ALJ got it right, then there's a decision issued, and the NLRB says, all right, here's the decision. You got to abide by it. The last step in the process is that the losing party can appeal the NLRB's decision to the Federal Court of Appeals. Typically in discipline or discharge cases, if the employer loses at the National Labor Relations Board, they face very much an uphill battle trying to appeal that to the Court of Appeals, because the Court of Appeals reviews the NLRB's decision with a very differential standard. So the last thing I want to cover, and this is applicable to this is why we had this presentation, is how does the Nlra apply to charter schools? Well, first of all, it doesn't apply to public schools. State law determines how and whether public school employees may unionize. Some states prohibit public school unions entirely. It's like North Carolina, South Carolina, Georgia, for example. Depending on state laws, some can make it easier to unionize, and some can make it more difficult to unionize. But that's for public schools. That's dictated by state law, not the NLRA. Now, the application of the NLRA to charter schools, it's an unusual situation because charter schools are neither fish nor fowl. They are chartered by the state, but they are not public schools as you think of them traditionally. And for that reason, the application of the NLRA to charter schools has been unsettled. What complicates this issue is that unions at schools have taken different positions depending on the realities of the specific location. Unions in extremely union-friendly states have argued that the NLRA should not apply and that charter schools should follow the laws that apply to public school unions. Conversely, where the state law is less union-friendly towards public schools, unions have argued that the NLRA should apply. And in these two situations, the charter schools at issue have taken opposite stances. There's a fairly recent case involving the KIPP Academy Charter School. It was a school in Bronx, New York, where certain teachers were represented by a union, and they wanted to decertify, that is, get rid of their union. And the decertification process follows the same election process. If a majority of the teachers said, we don't want the union to represent us anymore, it would be decertified. Well, the teachers filed a decertification petition. The union asked the NLRB to decline jurisdiction, said, hey, you don't even have authority to hear this. The region, which oversees the elections, said that the NLRB had jurisdiction, and the union filed exceptions to the full National Labor Relations Board. And the National Labor Relations Board asked not just the parties involved, but anyone that they consider interested parties to submit briefs on a very interesting question. And it was, should we, as the National Labor Relations Board, declined jurisdiction over charter schools as a class. So should we just not wade into this area whatsoever? And ultimately, the board decided that jurisdiction decisions should be made on a case-by-case basis. So that being the case, what is the current standard? Under the NLRA, a state or a political subdivision of the state is excluded from its coverage. Now, what does that mean? Well, a state or a political subdivision is either created directly by the state to be a department or administrative government arm, or it's administered by individuals who are responsible to public officials or to the general public. So the analysis of whether a charter school falls within or outside the coverage of the NLRA really depends on state law then. For example, in Texas, the Nlrb has held that charter schools are a political subdivision because the Texas Education Agency, a public agency, can reconstitute a charter school's board of directors. And so because the board members of a charter school ultimately must answer to a public agency, the charter schools in Texas are a political subdivision of the state. The situation in New York and several other states in which there have been specific challenges, like Pennsylvania, charter schools have been held by the board not to be a political subdivision because private individuals and not the state control governance and structure. So in those states, the applicable state agency says, charters of charter schools say, hey, charter school, you've got our blessing to exist, but everything beyond that is handled by private individuals. In the private school context, generally, private schools are treated like any other private employer. The NLRA applies. Religious private schools, however, present a different and unique situation. Now, I discussed earlier about how standards often shift when a different administration gets to appoint the majority of the board. Well, this is one of those cases. So traditionally, the NLRA didn't cover religious private schools if the school held itself out as providing a religious education, it was organized as a nonprofit, and was affiliated with a religious institution. In 2014, the Obama board changed the focus of that first part from how does the school hold itself out to what functions do the employees that are seeking unionization, what function do they perform? And so the question became, do the specific employees at issues, the ones that would be voting, perform a role in creating or maintaining that religious education environment? Now, in 2020, with the board still being majority Republican appointed, it returned back to the traditional standard, looking at how does the educational institution hold itself out. Is another shift coming once President Biden appoints the majority? It's certainly possible. Our time is almost up, so I want to cover a few issues very, very briefly. One issue is the NRA in higher education. There's been a lot of arguments back and forth about whether teaching assistants are they employees of the private college. Currently, the answer to that question is yes. The Trump General Counsel tried to roll some of that back through a memo, and that memo got very, very quickly rescinded once President Biden appointed a new acting general counsel. The other kind of big topic that's in the news fairly often are college athletes. Are they employees of the private college? There's been actually proposed legislation by Senator Bernie Sanders. It's called the College Athlete Right to Organize Act that would give college athletes the right to organize under the NLRA.
And thanks, Igor. I think we're at our time. Thanks, everybody, for joining us today. Hopefully this was helpful. Again, I think you're going, as we have the Biden administration gets its full board membership going, you're going to see a increasing trend towards the NLRA applying, and we think it's useful for you to be aware of these rules if it does apply.
And there's one question that I think we can cover very quickly. Does Section 7 of the NLRA apply in any way to North Carolina charter schools, which are more like New York's, run by private boards, than like Texas's? Yeah, sure. I'm not aware of a case specifically addressing North Carolina charters, but I have actually read the North Carolina Charter School Act, and the question hits the nail on the head. They are run more like New York's than Texas's, where the state charters them but doesn't have any full-on administrative powers over them. And so I strongly suspect that if the issue came up to the NLRB, it would find that charter schools in North Carolina are covered by the NLRA and Section 7, just like New York's are under current board law.
And we have handled cases for North Carolina charter schools in front of the NLRB, and the National Labor Relations Board position has been that the NLRA does apply. So the short answer is yes, it does apply. Any other questions, Igor?
That's all we've gotten.
Well, again, I hope everybody finds this useful. And if you have subsequent questions, I think we can receive these for a period of time. And if we do, we'll reply to you directly. But otherwise, I hope everybody has a good day. And thank you for joining us.